Hello, my name is Mike Hobson. I'm with Bibb Community Media. Today we're in Centreville, and we have a special guest with us today, Mr. Robert Turner Jr. Robert is a candidate for district attorney in the 4th Judicial Circuit. That's hard to say sometimes. The 4th Judicial Circuit is a big circuit, isn't it, Robert?
Yeah, it is one of the largest circuits in the state of Alabama. Not necessarily population-wise, but land distance and the number of counties that it encompasses.
A lot of driving miles if you have to cover that whole circuit, isn't it?
It is.
All right.
A lot of driving miles.
So that covers Bibb County, Hale County, Dallas County, Wilcox County, and Perry County. And as Robert says, that's one of the biggest in the state. We call it the 4th Circuit. I can't remember how many circuits there are, but the 4th Circuit's right here in the central part of the state. And Robert is a candidate for district attorney. We're going to talk to Robert today about his background and some of the issues that affect the office of district attorney, which is based, his office, if he's elected, will be in Selma. Although I think Robert lives in Marion, isn't that right, Robert?
That's correct.
Right. He's been a lawyer in the 4th Circuit for a long time, and we're going to ask him to talk to us so that he gets to know the voters, or the voters get to know him. That's the purpose of this interview, because unless you hang around the courthouse a lot, you might not have had a chance to get to know Robert Turner Jr., and we want everybody who might be affected by their vote in the 4th Circuit to have a chance to get to know all the candidates, and that's why we asked Robert to stop by and talk to us today. So Robert, tell us about you. I've had the opportunity to know you for a while, but a lot of people haven't. So tell us where you're from, your background, and how you got your training and experience to qualify to become a district attorney.
Okay, I am a 2nd generation attorney. Fortunately, my father is an attorney as well, and the two of us practice together in the law firm of Turner & Turner. I've been practicing law now for 22 years. Can you believe that?
No, you don't look that old.
It'll be 23 coming up on September the 30th. I practice in a general practice firm. So during the course of my time as an attorney, I've practiced in the bankruptcy courts. I've done a lot of domestic relations work. I've practiced in Social Security disability. I've done some extensive work in that area. But the bulk of my practice is centered around criminal defense. I've been in criminal courts from day one. I think my bar results came in September 30th, 1999. Mm-hmm. And on October the 1st, I was in a district court having a bench trial on a criminal case. My training and experience as far as my education goes, we moved to Marion when I was 7. We moved from Birmingham, and I was a product of the Perry County Public Schools. I ended up graduating from Francis Marion in 1991. I attended Heiberger, which is right across the county line from Bibb, the Bibb-Perry County line. I attended 4th through 8 at Heiberger Elementary. After I graduated from Francis Marion, I obtained my bachelor's in business administration from Florida A&M in Tallahassee. I went to law school at Howard University in Washington, D.C., and I did all of that back to back. High school, straight to college, straight to law school. Mm-hmm. So I was able to finish law school at the age of 26.
That's pretty fast progress.
Yeah, so I started practicing in this area in the 4th Judicial Circuit in Bibb, Hale, Perry, Dallas, and Wilcox. I've had cases in all of those counties, jury trials in all of those counties over the course of the years. And I've also served in Dallas County as a child support referee. It's a pseudo judicial position, but you don't get the title, you don't wear the robe. Right. But that position was created to help diminish the number of cases that had backlogged in Dallas County, the child support cases.
Right.
So I've been doing that, and I do it now part-time. Most of the time it's twice a month. So that gets me in front of people, conflict resolution at its highest.
Right.
So I've been doing that for some time now. As a matter of fact, I think, and I don't want to I haven't looked at the statistics, but I was nominated for and named Judge of the Year by the Alabama Child Support Association, and that was with me not even being a judge. I'm still officially considered a referee. But some of the things that we were able to implement in the child support court in Dallas County really turned that program around. So right now, I'm still doing pretty much the same things that I did when I started practice. But we are a firm that's in a small town, but we have a statewide reach. We try cases all over the state of Alabama.
Well, didn't you serve as a municipal judge at one time also? Is that correct?
No. Now, my father was a municipal judge in the city of Selma, but
Okay.
I've never served.
That was not you.
That was not me. That's right.
Okay. So is the referee position, did you say you're still doing that?
I'm still
doing that.
Yes, sir.
Okay. Well, now, I know people confuse you and your father all the time when they don't know you personally, but your father's still active also, right?
He is. He is 76 years young, still active in all of his extracurriculars, and still actively practicing law.
Okay. So that's why it's easy to get the two of you mixed up when people only see the name of the firm. Robert Turner Jr. is you.
That's
and
correct.
We'll try to keep that straight today.
That's right.
All right. So you mentioned that you do a lot of criminal defense work, and you also mentioned that you've done a lot of jury trials. Is that right?
That's right.
In criminal jury trials.
That's right.
A lot of attorneys practice law for a long time and never try a criminal case.
That is correct.
So how many jury trials do you think you've done?
If I had to give an estimate, and that's what we're doing, because over the years, it's been quite a few. I would estimate that I've probably done at least 150 jury trials. That's not to be confused with trials, because many of our trials are bench trials.
Right.
And if you add those in, the number probably goes in excess of 600 or 700. But they don't usually take as much time. But jury trials, we've been over 100.
Right. Well, the public probably needs to understand, and I'm sure a lot of people get their information about trials from the television. Jury trials are not what we see on television, and I know it takes a lot of preparation. So,
it does.
Sometimes they can go on for weeks at a time. I won't ask you for your trial record. Nobody cares about that anyway. It doesn't matter. If you're in the district attorney's office, it will be entirely different for you
That's
to be on the
correct.
other side, won't it?
That's correct.
Right.
That's
So
correct.
that I won't ask you how that'll change your outlook, but I think
I
everybody-
will say this. It came this question in a somewhat different form, but pretty much the same question came up in a previous candidates forum, and I was able to, and I can truthfully say this, that during the course of my career, I can, on two hands, identify the number of criminal defendants that I represented that actually ended up having to spend time in the state penitentiary. And from the defense standpoint, that's a pretty good record. When you can, if I had to put a pen to paper, I could write down the names of my clients that actually had to spend prison time. Not to say that they weren't found guilty, because there's a distinguishment between that. Some people are given probationary sentences,
Right.
but people that were actually sent to the state penitentiary after the trial, it's been less than 10.
Well, that indicates a skill in negotiation, which you'll have to apply from the other side of the fence if
That's
you're
correct.
elected. Right.
That's correct.
Well, then I take it you feel that you're well qualified for the office, or you wouldn't be running. Is that right?
I do. 22 years of experience at doing anything, I think qualifies you for being able to apply or put yourself out for election to a position such as this.
Have you ever run for public office before?
I did. The first run, well, the only other time that I've run for public office was in 2006. I was 32, and I ran for a district judge in Perry County. And our current circuit judge, Don McMillan, was my opponent. The two of us ran against one another when Richard Avery retired from the district court bench. And we had a really close election back in 2006. The campaign was run clean on both sides, and the two of us have a really good working relationship even to this day. But I was a little bit younger then than I am now.
Right. You're smarter now, aren't you?
Definitely.
All right. Well, let me ask you this. You're running for district attorney. Used to be a few years ago, people might not have paid a lot of attention to the office of district attorney, that is, people who haven't been involved with district attorney. But today, district attorneys get a lot of attention because of the news and because of the things that are going on in our country. In some of the major cities, the district attorneys in some of those cities, because of their discretion that they have a lot of power in office, a DA does. And the power of discretion that they have to decide to prosecute or not prosecute crimes, and the effect of that has gotten a lot of publicity lately in some cities like New York and Los Angeles and Seattle, where we've seen a lot of violence and destruction in the streets for the last 2 years. And the impact of a district attorney or public prosecutor's decisions has been on display in the country. Now, I know we're not, the Fourth Circuit doesn't have cities like that, but I think everybody has tuned into that.
That's right.
So what would you have to say about the discretion of the district attorney as you seek to hold that office?
Yeah, prosecutorial discretion is something that people within the legal industry talk about all of the time, and it basically refers to the freedom and the obligation that the prosecutor has to look at accusations of criminal activity, look into investigations after they've been completed or sometimes while they're in progress, and determine whether a crime has been committed. And then if you determine that a crime has been committed, because there are varying degrees of criminal responsibility under the criminal statutes, the prosecutor has the ability to determine if a crime has been committed, what are we going to charge this particular defendant with? And that lies within the discretionary aspect of it. The thing that I think has happened so much publicly is there has to be transparency with the public. There has to be good communication with the public as to what are the elements that constitute crimes. You know, a lot of times what happens is people will see something that occurs and they'll immediately want something to happen. But one of the things that you have to do if you're operating in the office of a prosecutor is you have to look at the individual that's been charged with the crime. You have to look at how strong is the evidence, what does the law say as far as it pertains to certain immunities, what does the law say as it pertains to certain defenses. And then one of the things that has crept into the criminal justice system and kind of assumed a seat at the table now is so many states have strengthened their stand your ground laws. So many states have strengthened their self-defense laws, their justifications, and you have to look at all of that, you know, as a prosecutor to determine whether or not you're going to bring cases. What I plan to do is just to bring a fairness and transparency to it. I want the law to be equally applicable to everybody, regardless of what your economic status is, regardless of what neighborhood you live in, regardless of whether you're a Southerner or a Yankee, whether you're somebody who just moved into town or whether you're somebody who's lived here your whole life. There have to be some fundamental things that we look at, and fairness is fundamental. And that's what I plan to do on that. As far as the other aspect of what you're talking about, the other side of that coin is if you are elected as a district attorney and you're serving as the chief prosecutor for a circuit, and here we're talking Bibb, Hale, Dallas, Wilcox, and Perry, I think that the prosecutor needs to be able to effectively communicate to the public, whether it's during a private meeting or whether it's in a public setting, effectively communicate so that people can see and click and clearly understand what position you're taking and why you're taking it. And that's one of the things that I, would hope that I'll be able to do for the people of this circuit.
Well, I agree with you. I think a lot of times positions are taken of not speaking on criminal matters, and the shield of a criminal investigation is underway is used to prevent making public statements when the public needs to know what's happening.
That's right.
And a statement could be made to help people understand what the law enforcement is doing.
That's right.
So if that's what you're trying to say should be happening, I think the public would support that.
And I definitely think that should happen. We can even take that question and kind of segue it into another direction. One of the things that I've learned in practicing criminal defense, and I use this analogy, some people like it, some people don't, but I tell people that Alabama's famous football coach, Nick Saban, is now renowned for his defense and the attention that he plays to defense. And his teams are traditionally, until football went into this past happy mode that we're in now. But he made his mark in the college ranks, professional ranks, and then college again by the strength of his defenses. Mm-hmm. But a lot of people don't know that he spent the majority of his playing career on offense.
Right.
And one of the things that he says is that you learn about defenses and their weaknesses by virtue of the offense's experience. As I am pursuing the office of the district attorney, my experience as a criminal defense attorney has shown me that a lot of times there's not enough communication between the two sides about all of the nuances and all of the circumstances involved in the case. And there needs to be more. On the campaign trail, that opinion that I formed from being a defense attorney, that look, if we can just sit down with the prosecutors and find out not only what happened, but why did it happen, we will be able to bring cases to a faster resolution. What's happening, and this is coming from a lot of people that have been victims of crimes, mm-hmm. families that have been victims of crime, business owners that have been victims of crimes, they don't even know when the defendant is coming to trial. They don't know whether the case is considered to be a strong case or a weak case. They're not given enough opportunity to offer their input as to what they would like to see the resolution being. And I think that when you're a part of a community, you just cannot neglect those things. You have to keep the victims involved. You have to have your finger on your pulse. Your finger has to be on the pulse of the community, the pulse of the case, so that you can make sure that you are, doing the community a service. And that's one of the things that I think we definitely need to look at.
Absolutely. So those are issues that are going to be with us for a while, and I think that's not going to go away. The other issues that keep coming up every time the legislature meets and every time there's a public forum, I think there's a couple other things that we could talk about. One of them is sentencing reform. We have a lot of discussion every time we start talking about overcrowded prisons, which Alabama has plenty of.
That's right.
About the need for getting people moved along in the system and changing the sentencing guidelines and getting people out that are not necessarily there for violent crimes. Perhaps we have people who are sentenced to incarceration that could have an alternative sentencing plan that's different from what we are accustomed to.
That's right.
Do you have anything you'd like to say about sentencing reform and the need for it in Alabama?
Yeah, I think one of the things that I bring to the table, based on the 22 years of experience, is I've dealt with clients that I know they were guilty. Mm-hmm. I know that if they are able to beat this charge, which is what is how it's commonly referred to sometimes in the street, that there's probably a high likelihood that what they've been accused of will happen again. By the same token, I've represented individuals who truly made a mistake or had a lapse of judgment for a short period of time that has long-lasting consequences. But they are people that can be rehabilitated. They are highly remorseful. And when they were given the opportunities, they restructured their lives. And if you were to meet them now 10 to 15 years after they picked up the case, they are productive citizens, they're wives, they're husbands, they're good mothers and fathers, and nobody would ever know that they had ever really gotten in any trouble. I say that to say, as a prosecutor and even as defense attorneys, we need to make sure that our investigation into these cases, we find out who the people are. We find out, when our criminal justice system was first created, jail was meant to rehabilitate.
That's correct.
If we go back in our history and really look at it, I'm not going to say that it was a privilege to go, but not everyone was allowed to receive rehabilitation, because the first jails actually allowed people who needed to be trained or to be given skills. That's a place where they went so that they could come out better individuals and possibly not reoffend. That concept has long gone. It is applied sporadically in different places, but I think that we do need to do what we can to identify people that we feel can be rehabilitated. That would mean that not everybody's bail will be the same. As far as sentencing goes, judges conduct sentencing hearings. And the real purpose of sentencing hearings is so that the defendant can be humanized or dehumanized, depending upon what the case is. But the judges need to get complete pictures of who we're dealing with. And if we could start getting to the point where we don't just treat cases like numbers, and when we treat cases like numbers, we forget that each individual, each person that God created is different than the other. And we need to take the approaches that we can identify people that can be rehabilitated and allow those sentences or those sentence recommendations to allow for that. A lot of times I don't think people spend enough time figuring out, if we get this person out, and that goes back to how I started, if this person is allowed bond or if this person is allowed probation, what is the likelihood that they're going to reoffend? And there are ways to identify that. You can't be 100%, but a lot of times prior behavior is the best indicator of future performance.
Well, sometimes the sentencing recommendations and the pre-sentence investigations don't include anybody in making those but law enforcement themselves.
That's correct.
Isn't that true?
That's correct. But if you look at the actual pre-sentence interview form, and it varies a little bit from jurisdiction to jurisdiction, but there is an expectation that when the probation office interviews an individual, that they give that person an opportunity to identify their skills, their abilities, people that could speak up on their behalf, their educational background is designed to be extensive. But oftentimes, and I'm not just speaking of this circuit, because our circuit's got some good probation officers, but we practice law all over the state. And a lot of times we have seen reports where all they did was go talk to the kid at the jail, and that's it. And the recommendation is jail time.
So essentially, the the report is not a full review of the defendant's ability to possibly overcome his environment and his background. You
That's
don't get
right.
the full picture.
That's right. And that's not all the time, and that's not every place, but that happens in a lot of places across this country, and I think that it leads to some of the overcrowding
Right.
of prisons that we do
Right.
have.
It's the well, I probably said enough about that. Well, sounds like that you're aware of some of the problems. Perhaps if you're in office, you could have some influence on changing that or influencing that. Another topic I want to ask about is bail reform. You mentioned that there could be some legitimate reasons why the bail schedule might be deviated from in some cases. You support that, right?
I do.
Okay. So I won't spend a lot of time on that. How do you feel about eliminating this idea of cash bail or no cash bail? I guess is the language is always confusing, but essentially not requiring bail, the way they treat it in some places these days, where you can get out of jail free without bail. Whatever label you apply to that, we've got people being arrested and walking right out the back door of the jailhouse in some states. We're not doing that anywhere in Alabama, are we?
Well, I think what happens when we start discussing the cash bail is the argument from the people who want to get rid of the cash bail system. It tends to be that the majority of people who get involved in the criminal justice system come from economically deprived backgrounds.
Mm-hmm.
They're not as affluent as some of the other people for whatever reason there may be. And what happens is what might be a small bond to an affluent person or to a family with resources can end up being a de facto jail before trial for a person who does not have the financial means. So there's been an argument and a push towards eliminating the need for people to come up with so much money in cash or to provide a certain amount of money to a bail bondsman in order for them to get out. And I think the argument primarily centers upon the fact that there are some people who can make bonds a lot easier than others.
Some who can't.
And some people, I mean, you're basically telling them when you give them a bond that's really high, that you're basically going to be sitting here until you go to trial. And that is not a problem. I'm not necessarily opposed to that. But one of the reasons I'm seeking this office is if a person is being held and it has been determined that they cannot make bond, every effort should be made to get that person in front of a judge or a jury as soon as practically possible. And what is happening, and COVID plays a little bit of a role in the delay in some of the cases that in our circuit that have gone to trial. But we've had a backlog of trial prior to COVID. And when the bonds are the deterrence from people being able to get out and work and actually be treated as if they're innocent until proven guilty, then we need to make a more concerted effort to speed up the plea offer. And if the plea offer is rejected, get people in the court as soon as possible. So as far as bond goes, there are so many different factors, and I know you know,
right.
But to the general public, whether a person is granted a low bond or a high bond depends on the bond ranges that the state has already implemented. The judges have a wide discretion. But bond depends on whether a person might, if they are let out, are they a flight risk? You know, if we let them out, say for example, a guy comes through and we're in Centreville today. A guy picks up a pretty serious charge in Centreville, but he's actually from Centreville, Ohio.
Right.
If we allow that person to have the lowest bond possible, how can we guarantee that once he leaves,
Not likely,
he's going to come back? So there are just so many different things. Your prior criminal history, your work history or lack thereof, A lot of times we have to take all of those things into consideration. But I think we do need to take a look at if a person can't make a bond after it's been set and he's just sitting there or she's just sitting there for a long time and the family can't pay. I think that there needs to be something done within our system to kind of address that.
Okay. Well, in most circuits, and I know in the Fourth Circuit, we've had deferred prosecution for first-time offenders in many types of cases, but there's been a lack of mental health courts or mental health resources for a long time in many cases. I don't know if we're going to have that anytime soon. Maybe that's in the works. But I'd like to know where you stand on the continuation of deferred prosecution type programs and mental health programs for those who need that.
I am a proponent, I am a supporter of pretrial diversion programs, deferred prosecution programs, and I know we're using a lot of legal jargon, but what happens in deferred prosecution and pretrial programs, they're generally geared towards people who commit non-violent offenses.
Right.
They're offenses that involve property, theft cases. We're dealing with cases that don't involve violence. Sometimes they involve substance abuse. Whether it be alcohol or whether it be marijuana, which seems to be gaining a lot of popularity. I wasn't around during the Woodstock days, but
right.
I cannot imagine it being as prevalent or talked about as much as it is now. But those types of programs are generally designed to keep nonviolent offenders out of the jails and on the street, and then give people an opportunity to clean themselves up, make amends, pay their restitution, and receive whatever they need. So I'm a big proponent of those programs. Now, what I want to do, and I think this was the lead into this question, my criminal defense experience has shown me that a lot of clients that I represent have serious, identified, documented mental health issues.
Yeah.
If the city police officers wanted to go into these neighborhoods and arrest one of these individuals who suffers from a mental illness every night, they could probably find something to arrest them for.
Right.
We currently do not have a mental health court. If we have one, it's something that the prosecutor's office has not let the defense bar know about.
Right.
The way that it should be. But that would definitely be something that I want this circuit to address, because the mental health issue in our communities is probably one of the biggest problems we have. The sheriffs don't necessarily want to keep housing people who they know, after they have them in jail a couple of days, a couple of months, have serious mental health issues, because that becomes an expense on the state. The families who have to oftentimes manage their loved ones who may not take their medicines or may not be able to consistently purchase the medications that they need, they don't want them at home. And so jail ends up being where a lot of our mental health challenged people land. So
right.
I think that a mental health course would help us big time.
Right.
The other thing is I'm talking about Alabama. I'm not talking about the New Yorks, the Californias, the Floridas, the bigger states, or what have you. But there are courts in Alabama that also have veterans courts.
Right.
And veterans courts are important, because we have a lot of people that enlist in the military, at young ages, but they go and do grown and adult tasks. They fight wars. They are on the front lines. They've seen things that a lot of civilians have not seen. And then when they come back, the readjustment period is tough. And there have been veterans courts established to assist veterans who might be suffering from PTSD or other illnesses or other situations that cause them to be caught up in the criminal justice system. So I think we need a veterans court here, because there are a large number of people from rural areas, Perry, Dallas, Hale, Bibb, Dallas, they go to the military for opportunity, because our job market is somewhat depressed. But
Absolutely.
then when they want to come home to be around their mom or their dad, and they come home a little bit different, they end up not being welcomed or accepted,
Right.
or having the opportunities that they need to
Right.
succeed.
All right, well, let's wrap up here with a couple of questions that are directly related to your race as against your opponent. In your case, this is probably different from a lot of political races. Your job today as a defense attorney, you've been practicing law against your opponent for a number of years. He's on the other side of the fence. So you know him pretty well because you work regularly on the opposite side of the bar. Now you're running as a political opponent for the same office, district attorney. What are the main differences between you and him as you consider seeking office? What differentiates you from him that makes you a better choice for the voters who are considering their vote when voting day comes in May?
I think the thing that jumps out to me is, in all of the years that I have tried cases in this circuit, I've tried many cases against, the assistant district attorneys that have worked in this circuit.
Right.
But I have never, in the 18-year tenure of our current district attorney, I've never tried a case that he was on the other side of. What I bring to the table is the willingness and the ability to go into the courtrooms, to interact with the jurors who are comprised of the citizens of this circuit, and actually allow them to see and benefit from the years of experience that I have by actually trying and helping assist these assistant district attorneys with the tremendous backlog of cases that we have. The other thing is, I believe that the victims need to be kept in the loop with the status of their cases. They need to know the strengths and weaknesses of the cases that we'll be bringing on their behalf.
Right.
And I plan on making sure that we do a better job of letting them know when the person that's accused of offending you has a date in court, and letting them know that you've got an open invitation. Unless COVID rules are just preventing it, you've got an open invitation to be present every time that defendant comes to court.
So better victim notification, right?
Yes, sir.
Okay.
More hands-on approach to combating the backlog of cases.
I have no idea what the status is like in the Fourth Circuit on criminal cases. Is there a big backlog presently?
There is. We have in Dallas County, there are over at least 40 cases where defendants are charged with capital.
So
That means that they have no bond, and the case won't be resolved short of a plea or a trial. From the defense standpoint, something that we see a lot in this circuit is there aren't many settlement proposals put forth to even bring the cases to a resolution. In many instances, we've had obstacles with exchanging the evidence, and that's something that is fundamental to the criminal justice system. Every person that's charged has a right to know what they're being charged with and being presented with the evidence that'll be shown against them in trial. And the sooner that information exchange takes place, the sooner we'll be able to resolve them. And I plan on definitely doing that. We're behind most of the state from a technology standpoint. Many jurisdictions are allowing exchange of evidence via email, and it's electronic. And it's not something that you have to go in front of the judge and say, "Judge, they won't give us our discovery." This is an automatic right. In some counties, right around hours. By the time you go to your first call, but definitely your arraignment, the district attorney's office, in cooperation with law enforcement, has completed their information, their evidence, and given it to the defense so that you can counsel with your client and we can bring these cases to either trial or settlement. And that's one of the things that I want to do.
So, slow discovery. How long is it taking to get a case to trial now? I think I saw some capital cases here in Bibb County from 2019 last week. Does that sound all right?
That sounds right, but there are cases that date back to 2013, 2014, 2015.
Okay.
That was a case, it's actually a Perry County case that ended up having to try in Wilcox County that just concluded on yesterday. And I want to say that that case is a 2015 or 2016 case that went to trial in 2022 for the first time. And it resulted in an acquittal of the defendant.
Was that defendant in jail for that entire time? So 7 years of incarceration and an acquittal resulted.
Exactly.
Okay. I get your point. Any other differentiation that you want to point out?
The other difference is I've known the district attorney for a long time, and we've run in my view, a fairly good campaign. We've stayed out of the mud. But one of the things that I think I will bring to the table is I believe in fostering professional relationships between law enforcement, the judges, and the district attorney's office, as well as the defense counsel. Mm-hmm. I think I'm less combative when it comes to the media, when it comes to, passing out blame. I believe that there's no reason for me to belittle law enforcement officers who are doing the best that they can in some instances without offering help or assistance as to how can we work better together. Same is to be said with judges. Judges are not the enemies of the state. Judges are not the enemies of defense attorneys or prosecutors. And there has to be a working relationship because cases are made every day. And we have to be professional enough to not get bent out of sorts to where we start making disparaging remarks or pitting one of these particular agencies against the other. Because our system is properly named, even though people oftentimes don't name it properly. It should be called the criminal justice system and not just the criminal system.
Right.
And all of us have to cooperate and play our part in making sure that justice always remains our focus and not just wins and losses.
Right.
We are arguers, we are litigators, but that does not have to come across in every conversation that we have. People deserve to be respected. One of the things that I've noticed a lot of times is that too oftentimes we throw out labels at people, thugs, gunslingers, and things of that nature.
Yeah.
I believe I can be just as effective in prosecuting you and calling you by your full name.
Right.
Mr. Johnson was arrested last night. Our officers have conducted a thorough investigation. We are sure that we have the right person. He has able-bodied counsel. I know his lawyers. I respect them. What we want to do is to make sure that the victims of this crime receive what justice is and that Mr. Johnson is afforded all of the rights of his due process. Mm-hmm. I can detest what he did. I can hate what he did. But I don't have to disrespect him publicly nor his family.
That's right.
And that's one of the things that I want to do. I want to bring courtesy. I want to bring professionalism. I want to bring toughness, but I want it to be toughness that is not exclusive of seeking truth and justice.
Okay. Well, I think that we probably should wrap this up because people are going to get tired of watching us on this video here. And I appreciate your time today coming up here and talking to us. Now, this video is going to run on our platforms here in Centreville. It's also going to run with the Marion Times in Marion. It'll also run with the Selma Sun, and a lot of people will get to see it. So I'm going to let you close today by making any kind of statement you'd like to make about your candidacy, and just address the voters and say whatever you'd like to say to wrap this up.
Okay. I want to encourage everybody to just remember the date, May 24th, 2022, and go out and vote. Oftentimes we complain about our society and what's wrong with it and what's right with it, and we stay on the sidelines. I believe that this is an important election, and I think that it's important that people get out and vote. I used to always say I hate it when candidates say, we just need a change, we just need a change, because I want the candidate to identify what that change is, because that's always a catchphrase. But I believe that if you go out and vote for me, you're voting for somebody who knows this area. I'm in Bibb County today. I've played against the Bibb County Choctaws and the West Blockton Tigers, the Greensboro Raiders, the Selma High Saints. I grew up in this soil. I have a love and an affinity for all of the counties in this area. And I've seen from the defense side so many areas that we can shore up on the prosecutorial side that would benefit the citizens, benefit the victims of crimes, as well as the people accused of crimes. It takes far too long for justice to be meted out in the 4th Judicial Circuit. And I believe that I am the person that can do that. I can lead people, I can train people, and I can work beside people in a professional and courteous manner. And that's what this circuit is in need of. We need a relationship builder, we need a litigator, we need an administrator, and we need an awesome communicator, so that we can start to bridge some of the gaps that we've got in this circuit, and so that we won't continuously be an eyesore when people start looking at our county jails and the length of time that people have been housed in them.
All right. Well, Robert, we wish you the best with your campaign, and if you're elected, we hope to see you regularly here in Bibb County.
I promise you will.
All right.
All right,
Thank you, Robert.
you.
Good
All
to see you. Man, that was great.
Thank you.